Okay, I think we're good to go. So Leah, if you want to get us started.
I would be happy to. So hi, everybody. Thank you so much for joining us this afternoon for our 2020 Champions of Innocence event. So I'm Leah Georges. I'm the president of the Nebraska Regional Advisory Council, the Midwest Innocence Project. And before we begin, I want to cover a couple of announcements about our time together during this Lunch and Learn event, this virtual event. First, by way of a couple of logistics. So attendees will not be visible during the event. You'll be able to see us as the hosts and the panelists when we are on the screen. So feel free to eat your lunch as you learn with us. Nobody will see you doing that today. You can use the chat function to comment as the event progresses, to ask questions during our panel, but please be sure, if you would, to note whether you're sending a comment or question to just the panelists or to attendees and panelists. And during the panel, your questions will be shared behind the scenes with the moderator. We do plan to record this event, and so it's also being live streamed on Facebook and YouTube, so share it with your friends, there's still time. Please be aware that your name may appear somewhere in the recording depending on your participation, perhaps if you ask a question. Now, if you're a Nebraska attorney who would like to receive 1 hour of CLE credit for attending the program and you've not already let us know via that registration process, please send us an email following the event so we can report your name, and we'll pop that email address directly into our chat, so you'll see that here shortly. Now, be sure you stick around until the very end of today's program. We'll announce the winner of our door prize, a happy hour, socially distanced, of course, please, at your home, provided by Witch and Gnome. It includes a beautiful charcuterie board, appetizers, and wine for 8 to 10 of your closest friends. We'd much prefer that we share a breakfast or lunch with you in person, but we're really happy to be able to provide that for at least one of our good friends here today. Now, thank you so much to our sponsors, in particular our justice level sponsors this year, Baird Home, Hightower Ref Law, and Hauptmann O'Brien, Wolf, and Lathrop. We cannot do this work without you, and we are beyond grateful for your support year after year. Now, just as a little bit of history about the Nebraska Innocence Project now, as we function with the Midwest Innocence Project. The original Iowa-Nebraska Innocence Project was formed in 2005, and eventually we shifted scope to the Nebraska Innocence Project in 2008. Now, the project's primary goals were and remain to educate the public about the causes of wrongful conviction in Nebraska and across the country, advocate for policy reforms and legal best practices to reduce the chance that an innocent person might ever find themselves behind bars, and of course, to exonerate and free the innocent in Nebraska. In 2018, just several years ago, the Nebraska Innocence Project merged with the Midwest Innocence Project, and now we serve as a Nebraska footprint in the Midwest as the Nebraska Regional Advisory Council. Now, the role of our local advisory council is to continue to support the important work of the Midwest Innocence Project through fundraising, education, and continued reform, and to work to exonerate the innocent currently in Nebraska's criminal justice system. So thank you again for spending some time with us on this Friday afternoon. I'd like to introduce Rachel Wester, Nebraska Managing Attorney for the Midwest Innocence Project. Rachel.
Hi, thanks, Leah. Again, I just want to welcome everyone. Good afternoon, and thank you all for joining us today. It's a joy for us to all be here with people like you who showed up to this virtual event to support the Midwest Innocence Project and our work in Nebraska. So Leah sort of mentioned, but this event has traditionally been a breakfast event held in person in Omaha, but with the state of things, we shifted to this virtual Lunch and Learn program. We're really excited about it, but we also hope that you will give us some grace, as this is the first event we've had in this specific sort of format. So my hope for today is that by the end of the hour, you'll learn more about our work at MIP, our clients, and that you'll continue to support in our fight against injustice. So we're going to look at what we do at MIP, what our process is, a little bit about why wrongful convictions happen, and then we're going to start the panel portion of the program about halfway through. So first, just a little bit of an introduction so you all can have a concept in mind or context in mind as we go forward. What do we do at the Midwest Innocence Project? So we are a nonprofit organization dedicated to the investigation, litigation, and exoneration of the wrongfully convicted in a 5-state region. Our office is located in Kansas City, Missouri, but we work across Missouri, Kansas, Iowa, Arkansas, and here in Nebraska. And we have partners across our region. Studies estimate that somewhere between 2 and 7% of all inmates in America have been falsely convicted. And so that means that somewhere between 2,000 and 7,000 people in our 5-state region are currently sitting behind bars for crimes that they did not commit. That's an enormous amount of people. And for a little bit of context, we're a pretty small staff at MIP, although we've grown a lot over the past several years. We have 9 full-time staff members. 3 of those people are lawyers. I wanted to share a couple of other statistics to start us off, just for some additional context. So I checked this morning, and to date, there have been 2,676 exonerations since 1989 in the United States. And that accounts to more than 24,000 years lost in prison. Of those 2,676, 375 have been DNA exonerations. And we split those numbers up because we're going to talk a little bit later about the causes of wrongful convictions, and those causes vary depending on type. But we mean by that, by DNA exoneration, that the defendant was exonerated because some sort of testing done years after a conviction proved that they did not commit the crime. And at this point in time, there are approximately 3 exonerations per week. So I think these numbers are important just to give us some background and really show us that the problem of wrongful conviction in the US is pervasive, and it's also pervasive in the 5-state area that we cover. So before we get into more detail about MIP, we wanted to start with a presentation of an annual award that we give out. This is going to be our 2020 Champion for the Innocent Award. So we present this award annually in recognition of advocacy and work on behalf of the innocent. And this year's award winner is Tracy Hightower-Henne. Tracy has been involved with wrongful conviction work for many years and has a long history with the Midwest Innocence Project, and she's so deserving of this award. Tracy, for her day-to-day job, she started a law firm called Hightower Ref with Susan Reff, her law partner, in 2002, and she does primarily family law and criminal defense work. So I'm gonna stop sharing my screen right now and turn it over to Tish, our development associate, who's gonna play a short video now that highlights Tracy's work on the case of MIP client Juneal Pratt. Tish, I think we're having a problem with the sound.
In the type of work we do, freeing the innocent, there are people who work quietly behind the scenes, crafting meaningful policies, writing testimony, and creating relationships with stakeholders who can help make meaningful change. Then, there are people who are on the front lines, loudly and boldly advocating and litigating on behalf of our innocent clients. And occasionally in innocence work, you'll come across a person who does both. Tracy Hightower-Henne, past executive director of the Nebraska Innocence Project, is one of those rare and powerful forces in this work. My name is Leah Georges. I'm the president of the Nebraska Regional Advisory Council of the Midwest Innocence Project. In our work, we are presented with cases that appear impossible and by some legal standards are impossible. Post-conviction work, like the work Tracy has done, is full of closed doors, dead ends, and very real feelings of defeat for our clients. In all the years I've worked with Tracy, I've never seen her turn away from a closed door. She somehow finds keys to the doors that everyone else has thrown away, and in some cases, a battering ram, to break right through the no's that her clients have heard time and time again. And for Tracy, her cases are not cases at all. They are clients, people,
her friends, worthy of the hard work of digging to find just the right key.
So I became involved with the Nebraska Innocence Project in 2008 when I started my first job out of law school. I was working at a big corporation, which was like a dream job, and then I decided that I needed to find some volunteer work to do, and it came up on a Google search for some Nebraska volunteer work, and it was probably the best thing that could have come up for me. In 2009, Nebraska had passed the DNA Testing Act, and that was right around the time that I became involved. Then from there, we've done a ton of reform work in Nebraska for wrongful convictions, and I also continued to work on cases such as Juneal Pratt's case.
I'm Juneal Pratt. I was held in captivity for 42 years. If you can't imagine what that is, it's like 15,200 plus days.
Everyone believed Juneal was innocent and that there's more work that can be done on his case. The minute you meet Juneal in person, he's just got this personality about him that he has worked so hard on his own case that you just really want to be on a team with him.
My relationship with Tracy at the beginning was hopeful because someone else was willing to listen. I felt like God sent her to tell me, keep it rolling.
He could have admitted guilt 10 years into a sentence and probably been paroled. So for him to never have admitted guilt all the way up to his 42 years of incarceration, his quest for innocence and exoneration was the most important thing for him. I started helping review the transcripts and looking at them and refiling a motion for DNA testing.
What was remarkable when I met her is that by the time she came to see me, she knew the case. I didn't have to go through a whole bunch of jumps and loops to convince her of anything because the fact she had already taken the time to read the transcripts, to review the trial, to review the evidence, to review the warrants, everything. And so I found that quite impressive that she had put so much effort into helping somebody for free.
Juneal's case was really wrought with a lot of different issues that were happening in 1975 in Omaha. The crime occurred, the victims were white women, Juneal's a black man. We had those racial issues that were happening in 1975. Juneal was put into a lineup that we now know is the most absurd, faulty lineup I've ever seen.
I go in the lineup and they got two other guys in here and they got on street clothes. And I'm the only one with a jail suit on, and I'm like, wow, oh, okay, so they was basically targeting me, you know, like making me stand out. So a lot of things that they did was just so tricky.
When we got the evidence that I personally picked up from the med center, I personally took it to the UPS store to ship it to a lab in California. That was probably one of the neatest days of my career.
Tracy is a very sensitive and strong-minded person. She's self-governed. She's going to do her own research. She does her own logistics, and she knows when she go in how to debate her case. She don't go in raw. When she went before the Supreme Court in those oral arguments to convince that judge in this old case, her oral arguments, they're right on point. They're right to the point. Prosecution was all over the place, clearly. And so I guess she's a very dynamic attorney.
So Juneal was finally released in April of 2017. That day was one of the coolest days of my life. We had gone to many hearings before that where we thought it was going to happen in 2015 and in 2014 and in 2012. And so we really didn't think it was going to happen in 2017. And it did. And we went and had cheesecake and breakfast with his family, and it was amazing.
I mean, I walked out the door. It was just so wonderful. I think the first thing that came to mind for me was Dr. Martin Luther King's autobiography when he said in the book, "Unearned suffering is redemptive." And it truly has been.
This case has been something that has been one of the proudest moments, the biggest things that I've done in my legal career, which I think I have many more years to go in there. This case has taught me that wrongful convictions in this state happen, and they're continuing to happen, and they will continue to happen, and that every piece of the justice system really needs to take it seriously. But thank you so much for this award, and I feel really grateful for that, and I'm just proud to have Juneal always be able to sit by my side.
If I can describe Tracy in one word, it would be awesome, because she is. And she deserves the award, and there ought to be a big check attached to it too, so she can go snorkeling again.
Tracy has profoundly impacted justice in Nebraska for her clients like Juneal Pratt, and for those who may find themselves involved in the legal system in the future. We are many steps closer to a more hopeful future for the innocent because of her. Congratulations, Tracy. I am honored to present the 2020 Champion for the Innocent Award to my friend and a friend to the innocent, Tracy Hightower-Henne.
Congratulations to Tracy. We wish that we were able to give you the award in person, but we're glad that we got to have this video to highlight all the amazing work that you've done for the innocent, and in particular for Juneal. So give me 1 second, and I'm going to share my screen again. Okay, so we're going to move on and chat a little bit more about the Midwest Innocence Project and our work, and in particular our work in Nebraska, and some successes we've had over the last couple of years before we get to our panel. So I'm showing a graphic right now. This is a 2019 by the numbers graphic. We do one of these every year when we release our annual report, and it gives kind of an overview of how much work there is to do in our 5-state area. So you'll see here that there are 738 total cases. The biggest caseload is in Missouri, where our office is located, and you'll see that on this graph, it shows around 45 cases in Nebraska. So this number has fluctuated a little bit since then. Right now, there are around 49 cases in Nebraska. And this summer, we actually took those 49 cases and we did an audit. So we dug into files, we made decisions about which cases we're going to prioritize next, and we started collecting records and documents from clients, which is a big part of the process we have to do up front. And those 49 cases are at various stages of our process at MIT, our internal process for how we take a case. So I'm going to give you a little bit of an overview of that now. So at MIT, there are 4 stages in every case. The first thing that happens is if someone is looking for our assistance, they fill out an application for us, or they can have a family member or a loved one fill it out for them, and they send in the application. It's about 12 pages long. And we basically want to know at this stage whether they meet some very basic criteria. First, the applicant has to be claiming that they are actually factually innocent. So they can't be claiming that they didn't go inside the bank, but they were the getaway driver outside, right? They have to be saying they had absolutely nothing at all to do with this crime. And the other big thing that has to be met at this point in time is that an applicant has to have at least 10 years left on their sentence at the time they apply. And that's because with our current staff and resources, it will take us at least that long to even get to an inmate's case. So after someone meets all of the criteria on our application, we then move to the next stage in the process, which is screening. So in screening, we use volunteer attorneys for this, or law students. And this is really the first big deep dive that we do into a case. So we assign a law student or a volunteer to look through a case file, to review the case file, to digest the transcripts, trial transcripts that are in there, to look at police reports, to evaluate the case for us. And basically what we want to know is, are there investigative avenues that we could take that could be used to support the defendant, to build up what the defendant says happened, and to overcome the state's evidence against someone at trial. And we ask the question in this way. So in a hypothetical world with unlimited resources, where everything goes our way, which is the opposite of the world we're really living in, what could we do to prove that this person is innocent and to help overcome the evidence that the state presented against them at trial? And we also, in this stage, want to look at some hallmarks of wrongful conviction. Is there something that happened in this case that we know is a cause of wrongful convictions? So I'm going to show a little bit of some more statistics here. So this chart shows the contributing factors to exonerations. This is from the National Registry of Exonerations. And it shows the 5 leading contributing factors to wrongful conviction. So I'm going to go through these fairly quickly, but I just want to highlight each one. So the first one that you'll see on the left is mistaken eyewitness identification. In the around 2,000 cases that are reflected in this graph, eyewitness misidentification occurred in 35% of cases. Now, when we break this down to look at just DNA exonerations, I said at the beginning there have been around 375 of them since 1989. Eyewitness identification, a misidentification, occurred in 72% of those cases. So it is the leading contributing factor to wrongful conviction in DNA cases. The next one on the list is perjury or false accusation. This occurred in 57% of cases. And what we mean by that is typically some sort of informant witness, or you'll hear them called snitch witnesses. So maybe in a case where the prosecution's evidence against a defendant is a little weak, all of a sudden at the 11th hour, a jailhouse informant comes forward, someone who's been sitting in jail with the defendant while they await trial, and that person has evidence. They come forward and all of a sudden they heard the defendant confess to the crime, or they heard the defendant say some sort of other inculpatory statement, and they testify about that at trial, and then they get a deal in exchange for their testimony. So again, that happened in around 57% of cases. False confessions occur in 13% of cases. Again, when we break that number down to the 365 DNA exonerations, a false confession occurs in about 27% of cases, so 1 in 4, which is maybe a higher number than people might expect. And the last two are forensic science, bad forensic science, that occurred in 22% of cases, where a forensic analyst got on the stand and testified that 2 shoe prints or 2 bullets or 2 fingerprints matched. And in fact, we know now that a statement like that is not supported by science and it's not true. And the last one here is official misconduct. And there's actually been a more recent report than this graph I'm showing here that has told us that in all of the exonerations that have occurred thus far from 1989 until now, official misconduct took place in 54% of cases, so over half. So back to our process. So I talked last about screening, right? And that's where we're digging into the case file for the first time. And we're asking a volunteer to look for those hallmarks of wrongful convictions. Was there a potential false confession? Was there a possible mistaken eyewitness identification? And if we answer that hypothetical question of what could we do to prove this person is innocent, if there's something that we can do, then we will move that applicant on to the next stage in our process, and that is investigation. This is the boots on the ground stage, so to speak, where we start going out into the world and talking to witnesses, maybe a witness who has information, but the police or defense counsel never spoke to them at the time of trial. maybe a new witness that we've uncovered. We might talk to members of the jury who sat through someone's original trial. This is also the point where we would consider doing DNA testing. So is this case maybe an older case where DNA testing wasn't possible at the time of trial, but we have new technology and we could test relevant evidence now? And we would consult with expert witnesses if there's some sort of scientific issue at play. And then if after all of that investigation, which is normally a years-long process, if we think that there's enough that we can actually go into court and say that this person is innocent, we will litigate on a client's behalf. And at the point we get into litigation, we're really looking for the things listed out here on this slide. Can we find newly discovered evidence? Maybe that's new DNA testing that we did during the investigation stage. Do we have a recantation from a witness? So perhaps this was a case with an eyewitness misidentification, and now that eyewitness has come forward and recanted their identification. And the next one on here that we're going to look for on top of new evidence is we're going to look for ineffective assistance of counsel. So we have a constitutional right to have adequate counsel at the trial level. And we want to know if in this particular case, the defendant had adequate counsel, or did their trial lawyer not do some things that they should have done that would have proved they were innocent. Then we also want to look for prosecutorial misconduct. This is called Brady evidence. Oftentimes, Brady is the U.S. Supreme Court case that says that the prosecution or the state cannot withhold helpful evidence from the defendant. And so we're going to look for whether or not that happened in this case, and especially because we now know that 54% statistic where official misconduct like this has happened in 54% of all wrongful convictions. And the last thing we might want to look for is juror misconduct. Did something happen in the jury room that shouldn't have? And is that something that we could bring into court on a defendant's behalf? This is really a very small piece of what we're doing at the litigation stage. It's a very complicated procedural process that we don't have time to go over today, but just know that we need to have a very good amount of evidence that points to someone's innocence before we can go back into court on their behalf. So before we start our panel discussion today, I just wanted to highlight one other Midwest Innocence Project client on top of Juneal Pratt's case, who you heard about earlier today in the video for the award to Tracy. And Ricky is going to be part of our panel this afternoon. So I wanted to just give you some brief facts about what happened in his case. In February of 1996, 3 Black males robbed and murdered 2 men in Kansas City, Missouri. One of those men was found dead in the front yard, and the other one was found dead in the basement of the home. One of the victims, George Bryant, had a 4-year-old daughter who was actually present at the time of the crime, and she witnessed the murders and called 911. Ricky had what should have been an airtight alibi. He spent the day of the homicides with his girlfriend, Monica, and at the time that the crime occurred on February 6, 1996, Ricky and Monica were at the Jackson County Sheriff's Office at Lake Jacomo applying for a gun permit. But the jury chose not to believe that alibi, and instead they focused on some of the evidence that the state presented against Ricky. He was convicted based on 2 eyewitness identifications that were flawed and coerced. One of those identifications was from the 4-year-old daughter of George Bryant, and the other was from an incentivized witness who came forward a month after the crime and suddenly had new information and got a deal in exchange for his testimony against Ricky. No physical evidence tied Ricky to the scene, and the state withheld key evidence pointing towards the 3 actual perpetrators of the crime. Ricky was sentenced to life in prison without the possibility of parole. But Ricky's story has a happy ending. So after a very long fought court battle that started all the way back in 2003, when Ricky first filed a petition in federal court, he finally prevailed. On August 14th of 2019, Judge Atkins ruled that evidence established that Ricky is innocent, and he vacated Ricky's conviction. Ricky was released the very next day after serving over 23 years in prison for a crime that he did not commit. And I'm happy that you're going to get to hear from Ricky about his experience and about what he wants people to know about his case and wrongful convictions during the panel portion of our webinar, which will get started right now. So I'm going to end my screen share. And if our panelists could turn on their videos and unmute themselves. Hi, okay. I think that's everybody. So we're going to move on to the panel portion of our event today. I'm going to introduce our panelists and give a little bit of background information to you about each of them. And then I'll ask questions for a little while, and I'm going to leave some time at the end so that if you all have questions as we go, you can put them in the chat on Zoom. You can comment on Facebook or YouTube or wherever you're watching, and someone will get them to me so that they can get asked at the end. So I'm just going to do a little bit of a bio for each of you all real quick before we get started with the questions. So our first panelist is State Senator Adam Morfeld. Senator Morfeld went to college and law school at the University of Nebraska-Lincoln. In 2008, he founded and is the executive director of Civic Nebraska, which is a nonprofit that works to instill civic leadership in young Nebraskans and build civic health in our communities. In 2014, Adam was elected to the Nebraska legislature to represent Northeast Lincoln, and he was reelected in 2018 to a second term. As a member of the Judiciary Committee for the last 6 years, Senator Morfeld has introduced, co-sponsored, and passed numerous criminal justice reform laws. He was actually our 2019 Champion for the Innocent Award winner due to his sponsorship of a Midwest Innocence Project bill that provides transparency and enhanced discovery for jailhouse informant testimony. And Adam is also interestingly running to be Lancaster County Attorney in 2022, so he can make an even bigger impact in criminal justice reform. So Senator Morfeld, we're glad to have you. Next, we have Randall Ritnour. So Randall is currently the owner and managing attorney at Ritnour Associates in Lincoln. He has over 25 years of criminal law experience. And in 2008, Randy was the Gage County Attorney in Beatrice, Nebraska. And he actually led a joint task force that investigated the wrongful conviction of 6 people for the murder of Helen Wilson. These 6 people are collectively known as the Beatrice Six. You might have heard of their case and of their exoneration. The case resulted in a $28 million judgment against Gage County, Nebraska, and Randy's participation in that task force really changed a lot of his perspective on criminal justice, and so we're excited to hear from him today. And then last and not least, we have Ricky Kidd. So you heard a little bit about Ricky's story earlier. After surviving 23 years of being wrongfully convicted, Ricky has chosen to turn his experience into a positive one. He has begun sharing his story across the country, living in his freedom and helping others find theirs. So he's founded I Am Resilience, which is a global platform that helps people tap into their own resilience, something Ricky gained a lot of while he was in prison. Ricky is a justice advocate, a speaker, a playwright, and a community activist who's on a mission to advance current generations and future generations through positive impact. So we're so glad you're here with us today, Ricky. So I wanted to start out with just an introductory question to each of you. And Ricky, I'm going to start with you. So your case has several hallmarks of wrongful conviction. There were 2 flawed eyewitness misidentifications in your case, and there was also state misconduct. So the prosecutor in your case withheld key evidence that pointed towards the people who actually committed this crime. So I'm wondering what you think we can do to better incentivize prosecutors like the one in your case, and how can we prevent this type of misconduct from occurring again?
Yeah, absolutely. Thank you. Thank you, MIP. Thank you for everybody on the panel, as well as those in attendance today. Really appreciate the opportunity that we get to spend this afternoon talking about such an important issue, wrongful convictions here in America. Good question. Very, very good question, Rachel. I believe some of the things that we need to begin to look at to incentivize or help curb that over 54% of police or prosecutorial misconduct, as it was in my case, is taking a good look, a good hard look at full immunity and qualified immunity that police officers, qualified immunity, and prosecutors, full immunity. Take a real good hard look at that. But I just want to back up briefly. It was good intentional. I believe after I've looked at the issue, it was good intentional policy as it came into play. The idea for the listening audience and why prosecutors would even be afforded full immunity is because they did not want prosecutors to feel handcuffed or shackled or to be tepid in their approach to pursue justice. They wanted them to pursue justice with vigor and not have to worry about a consequence in the back of their mind. That did make sense many, many years ago. It really did. I suppose an argument could be made. But what we're finding now, as Rachel has highlighted in the National Registry, that over 54% of wrongful convictions, it has a direct correlation with police or prosecutorial misconduct. And so we have to take a look at that. Maybe some, not all, because I believe in good prosecutors. I believe they are our heroes, our modern day heroes, in my opinion. But we have to take a hard look and see who has began either directly or indirectly abusing their power and what should be done. Maybe we should take that back. Maybe we should add certain amendments in there to where if it is benign, if there's a benign mistake or a mistake that wasn't done intentionally, perhaps that should still stand. But if there's evidence that there was an egregious action taken, as in my case, my prosecutor, Amy McGowan, here on the Missouri side, in fact, she just went before the disciplinary board October 2nd. It was egregious what she did. In that case, we need to really look at that and maybe start holding them accountable. Lastly, I will just say, Rachel, if I can, what I think would be a fitting remedy is retraining, yearly training, annual training, where prosecutors are mandated to some extent of attending retraining courses where they are reminded what that looks like, what those code of ethics look like, and maybe they can be confronted with a speaker. As myself, I have shared my story in front of many individuals across the country as a cautionary tale, not as an antagonizing, finger pointing presentation, but as a cautionary tale that this is what happens if you make those mistakes. I think those two things is a good start in making sure that we bring that 54% down.
Absolutely. Thank you, Ricky. I think enhanced training is certainly really important, and re-examining that doctrine of absolute immunity also.
Yes.
So Adam, I'm going to come to you next. So we mentioned earlier that you've announced that you'll be running to be the Lancaster County Attorney in 2022. And in August, just about a month ago, you tweeted that one of the most important duties for a prosecutor's office is to ensure that no innocent person is wrongfully prosecuted, and that you support common sense reforms that allow Nebraskans to adequately defend themselves in court. So I'm wondering if you could just explain a little bit more about what you mean and about what sort of common sense reforms you think would be key in preventing wrongful convictions in Nebraska.
Yeah, you bet, Rachel. And thanks for having me, and thanks for all your guys' incredible work. I got to see firsthand all the experience, resources, and just connections and contacts through your great work that you have in my own work in passing LB 352, which is what you brought up briefly, which provides more transparency, particularly when it comes to jailhouse informants. So getting to your question, For me, what that means is really making sure that we have accountability and transparency in the sense that when you go to your county attorney's website, there, one, it's hard to find a number, to even contact anybody there to get information about things. Two, there are no statistics about charges or conviction rates or anything of that nature in terms of what's going on in the county attorney's office. I haven't even been able to find the budget for our county attorney's office. And so first off, I think there's some baseline things that we need to do. We need to make sure that in every single county attorney's office, we'll have what I call a public advocate. That is essentially a neutral ombudsperson in the county attorney's office, particularly the larger county attorney's offices. I know there's resource issues in some smaller ones, but in the larger county attorney offices, making sure that we have a neutral third party that can, number one, compile statistics on the charging decisions that are made, on the demographics of the people being charged, and then also having somebody that the public can come to and say, hey, something doesn't seem right here. You should know about this, and take a second look. I think it's incredibly important that we have checks and balances in the offices that have broad discretion in a sense that none of our other county officers have, and making sure that there's stopgaps and accountability and transparency. So if I'm elected county attorney, I'm going to make sure that we, number one, on day one, hire a public advocate, somebody who is a neutral third party in the office that can provide that accountability and transparency. Two, making sure, much to Ricky's point, making sure that we have diversity, inclusion, and equity training on a yearly basis for all prosecutors, making sure that we have other training, hearing from people who are actually been impacted by prosecutorial misconduct, like Ricky, so that people can understand the stories, interact, and always have that in the back of their mind. And this is not me saying that all prosecutors are bad. If I thought that was the case, I wouldn't be running for the office. I think they perform an incredibly important part in our community and our democracy, much to Ricky's point. But that being said, I think for far too long, we have not demanded or had accountability and transparency. Also, in Nebraska, we don't have county prosecutors really advocating for that. And so that's something else that I want to do, is I want to put together a group of county prosecutors that want to go down to the Capitol and not just oppose things like LB 352, which they strongly oppose that, even though that's very, in my opinion, low-hanging fruit in terms of the level of issues that we have. Important piece of legislation, but just a starting point. We need to have more county attorneys and prosecutors that are advocating for transparency and accountability, not only in their own offices, but systematically on the statewide level. And so that's another thing. We need to be providing leadership in that sense on the statewide level. And then that will in turn create more public trust. I could keep going on, but I'll stop there.
Thank you, Adam. Yeah, I think I agree with a lot of what you had to say, but I think one particular thing is that, as you said, it's important for prosecutors to hear from people like Ricky, who have experienced a wrongful conviction, and in particular, who had state misconduct happen in his case. I think that's so important to changing the culture within a prosecutor's office, which is really crucial to create systematic change. So Randy, my question for you is, we mentioned in your bio, you were the Gage County attorney, right? And you served on a task force on the Beatrice 6 case. So that was a case where 6 people falsely confessed to a crime, they were convicted, and then DNA evidence helped to exonerate them. So I was wondering if you could just tell us a little bit about your role on that task force, and also how that experience with the task force and with that case changed some of your views about criminal justice or wrongful convictions. So Randy, you're muted.
Sorry about that. I didn't want you to hear my dog in the background and all sorts of other things that are going on around here. Let me give you a quick background on me. That 25 years that I have spent as an attorney, I was a prosecutor, as an intern prosecutor in Boston. I was the chief prosecutor on an Indian reservation in North Dakota. I was county attorney in Johnson County. and then in Gage County, and also served as special prosecutor in a lot of other counties around eastern Nebraska. My first involvement in the Beatrice 6 case was when the Supreme Court ordered the DNA testing for Mr. White and Mr. Winslow. And at that time, what we did was can you hear me? Okay. At that time, what we did was we met with Jerry Susi and his private investigator, and we assigned Tina Vath, who was with the Beatrice Police Department. And we went down to the police department, and surprisingly, after 20 some years, the DNA evidence and a lot of the evidence for that case were still in the Beatrice Police Department's basement. And in fact, we even had liquid blood samples they're still liquid in tubes. And we took about 13 pieces of evidence, and we sent it up to the UNMC lab and got DNA from Mr. White and Winslow, and proceeded with that case. We didn't hear anything for about 8 months. I didn't know anything about the Beatrice 6 case other than I had heard that 5 of the 6 people had confessed to the killing, and that, of course, Mr. White had gone to trial and been convicted. So as far as I was concerned, this was a slam dunk. We were going to hear back that the DNA did, in fact, show that these people were there, particularly since they had all confessed. When it came back, at first only 2 items of evidence were tested, and they came back and showed that these 2 individuals were not in that DNA group. I was not yet convinced that any of these people were innocent, though. And so what I did was contact the Attorney General's office, who we'd been working with John Bruning on a number of cases. We had just actually finished a murder trial in Beatrice when this came up. And I told him, look, I'm gonna need some more resources, because I just don't have the resources in Gage County to do this. And so I'd like some help from the Attorney General's office. So we agreed to set up a task force. It was a joint task force between the State Patrol, County Sheriff's Office, the Police Department, Beatrice Police Department, and my office. And each agency had their own lead, but I led essentially the task force there, and I made the decisions with respect to what happened. So what we did was we found out that they were close to 13, well, there were 13 items of evidence, only 2 had been tested. So we filed an action to actually get the others tested, because we thought, well, okay, we need to make sure that evidence will show those other people. And we were allowed to do that. And in addition, we asked for 30 additional items of evidence to be tested, and that was granted. And so we sent it out to 4 different laboratories, and some were in other states, and they tested different types of DNA evidence and different types of with different types of tests. And over a series of weeks, all of that came back as one unknown male and the victim. So we had actually intended to prove that these people were in fact guilty, and we had to, at that point, begin to reinvestigate the entire case. And so we turned from a group that was going to confirm the convictions to a group that had to reinvestigate the entire case. We did that. We actually went through the original evidence of the Beatrice Police Department, and that case had gone cold. There was a deputy, actually a former police officer, who decided on his own to go after the case while he was a private citizen. And in fact, he wandered around telling people, I'm a private investigator, but don't tell anybody yet because I haven't got my license yet. And then he proceeds to come up with a theory, and then once after a couple of years, actually got onto the Gage County Sheriff's Office and became a deputy. That's when he presented it to the then county attorney and the county sheriff, convinced them to go ahead and permit a case to begin, or an investigation to begin under the sheriff's office, under his control. And he began to pursue this case. We found out that 4 of the elements that you listed as contributors for wrongful convictions occurred in that case. We had false statements by an informant. We had misdirected DNA evidence. The only thing we didn't have was a mistaken witness ID. And what we discovered was that Beatrice Police Department actually had the right guy at the very beginning, and his at that time they were using serology, rather blood serology, as for evidence, not DNA. However, DNA was available then. The former county attorney made a decision not to do DNA tests because it would cost too much money. The amount it would have cost was $650. Now, what happened was that the Beatrice Police Department, along with another agency, went down to Oklahoma, actually got a sample with the help of the Beatrice City Police, or excuse me, the Oklahoma City Police. And it turns out that, well, they wanted it tested in Oklahoma City. Turns out, and I don't know if you've ever heard of a lab administrator by the name of Gilchrist, but her lab was the one who tested that, and they got it wrong. She was actually fired after falsifying numerous lab tests in a way that was similar to the Douglas County case that where we had the head of that lab convicted and sentenced. But in any case, the case went cold because she misidentified that particular lab test, showing that it was not him. And so that's how the case kind of developed over time. And what we found was that all sorts of just crazy things happened with the Gage County case that finally resulted in the conviction of these individuals, mostly through plea bargains and then, of course, through one trial. We then, I made the decision that I was not going to retry Joseph White's case. And we worked with the Attorney General's office to move to get the other 2 individuals that were still in prison out, and well, actually 3 people, including Mr. White. And then the Attorney General's office, for the first time in the history of Nebraska, actually asked for pardons for all 6 of these individuals, and we did gain those.
Randy, I actually have a, I actually have a related question that I was hoping to ask you and the rest of the panel, which is about something you just mentioned, which is plea bargaining. And so we had a question come in from the chat about that as well. So I know you kind of took an interesting stance on plea bargaining during your time as prosecutor, Randy, but I want to get Adam and Ricky's perspective as well. Sure. Many people suggest that perhaps plea bargaining and pretrial detention in particular, which causes plea bargaining, is the most common cause of false convictions. Someone is sitting in pretrial detention, unable to pay bail, and then they in turn plead guilty out of desperation. So I know, Ricky, you were in pretrial detention before you were convicted. Did you feel that kind of pressure to plead guilty? And do you think there's something we can do to get rid of this incentive?
Yeah, I did spend a little short of a year, about 11 and a half months before trial. And I did not feel pressured at all. An innocent man, in my mind, no way. They could have offered me 15 days time served and I would not have took it. And I'm not just saying that. No, and my mind cannot compute pleading guilty to anything when I was absolutely innocent. In fact, I was crying so much to my public defender that she bought a colleague, a public defender colleague over. And I don't know if he was trying to keep me calm, but he was, get me out of here. I'm innocent. And he was like, well, we can get you a deal, maybe something like 7 years. And the left part of my brain is thinking, a double homicide, 7 years? Are you serious? The right part of my brain was screaming, I'm innocent. Why would I take a nickel? Why would I take 15 minutes? And so that was my experience, just frustrated that he was even willing to either keep me calm or seriously could have somehow negotiated a deal for a double homicide for 7 years. It does speak to that our justice system, in my opinion, when it comes to plea deals, is off balance. It is really off balance. You will scratch your head, and if people really knew, and what Senator Adams was talking about, accountability, and then that public report card, so to speak, because people would scratch their head if they knew what type of deals was being offered. If we're being honest, if we're being transparent, and if we're talking about integrity and our advocacy, which I often speak on, one guy, same type of crime, heinous, probably needs to be off the streets. You're going to get slammed 30, 40 years, but somehow over here, the same guy is going to get 3 to 5 to 6, 7 years. It seems oxymoron to me, seems like a huge paradox. To my final answer to that is, I'm not as versed, to be transparent in my response. I'm not as versed in giving a serious, educated answer, but I will say this for what I do know: we cannot do away with plea bargain. I don't believe. I know 95% of cases result in a plea bargain. Our system would have a problem. We would have a bottleneck problem. No way possible can we get rid of it. Sounds more simple to say, but I don't think we can get rid of our plea bargaining system. We may can fine tune it. We may can find some uniform metrics to use and why prosecutors decide to deal less than more. But to get rid of it, I think we have to take a real good look at it.
Yeah, I mean, I'm actually kind of interested in Randy's thoughts as a former prosecutor on this. But the one thing that I will say is that I think this goes back to the transparency part. For instance, we need to be keeping track of how many people are charged with what. And then did it result in a plea bargain? And if so, what was that plea bargain? One of the interesting issues that I've heard about in Lancaster County, I wish I could get more data on it. They sent me a $35,000 bill if I wanted the data. But one of the things that was interesting in Lancaster County was that they were charging people with felony marijuana residue possession. So we're just talking residue, and then they would charge them with a felony, and they almost always pled down to some kind of serious misdemeanor. But for instance, I think if people in Lancaster County saw how many people were charged with felony marijuana residue cases and saw the plea bargains, there would be a little bit of an outcry, or at least questions that would then naturally hold people accountable to justify that. But without that information, and without the ability to do that, without getting $35,000 together to get that information, it's really tough to ask those questions and hold people accountable. But I'd be interested in Randy's position and his approach on that with plea bargains.
Well, I'm a bit of an outlier in Nebraska. I'm the only county attorney that I know of that has ever actually instituted a no plea bargain policy. I did that after the Beatrice 6 case, but had been considering it already. The reason I'd considered it is because if you go back to the mid-70s to Alaska and you look at the attorney general there, named, I believe it's Arvid Gross, he actually declared a no plea bargain policy in that state. The judiciary and the rest of the bar decried it and said that it was just going to clog up the system and stop everything. What he actually found was, and it went on, I think his no plea bargain policy lasted for at least a decade, if not two. What he found was that if he set up a policy, which he did, which said, we're not going to make any recommendations at sentencing because that's the job of the judge. We're going to charge them with what we know that we can prove. What he found was that the police departments and law enforcement agencies actually had to be more careful about what they brought to the attorney general, because those state's attorneys and attorney generals would scrutinize those cases a little more carefully to make sure that they had what they could prove, and they would only charge those things that they absolutely were sure of. Now, that's what they're supposed to do ethically. That does not, in fact, in practice, happen sometimes. There are times when you'll see law enforcement agencies throw as much stuff at the wall as they can to see what sticks, and that way they have room for plea bargaining. But what he found was that his trial cases only went up 2%. It actually streamlined the system, and they were actually more efficient that way. But let me tell you that it's a whole lot easier for a prosecutor to make a plea bargain and not face the work of preparing for trial and going to trial, because a lot of your work when you're dealing with trial is preparing for it. You put down a lot of work in that, and if they are able to, it's just natural. People will want to go ahead and go after plea bargains. So eventually, even in Alaska, that plea bargaining system went away. Now, my experience, I had the last year and a half of my term under a no plea bargain policy. My experience was that the judiciary was angry. I got a lot of trouble from them. County attorneys, after I announced it publicly, were scrambling all over the state to explain to their constituencies why they couldn't do that. And it was just a political nightmare for me, but I said it publicly so that it would hold my office's feet to the fire and make us do it, rather than say we were going, quietly say we were going to do this and not, just mush around about it. So what I found was, in fact, we had more convictions. We had less time spent futzing around with people, arguing back and forth, telephone calls all the time for various defense counsel. And we actually had no fewer trials. So it was an efficient system. I actually was a little more relaxed in the last year I was in office. I got primaried, so I wasn't going to be in again. But it was a much more relaxing atmosphere, and we could actually make sure that we prosecuted people for what they did. And so if I have a DUI, I'm going to charge them with a DUI. I'm not going to charge them with no bad headlight and speeding over 10 over or whatever else, to add those extra things, because that's the deal with plea bargains. You have all these little charges that you drop just so you can get to the charge you really want in the first place. So essentially, it works, but I don't think anybody's going to trouble.
Thank you, Randy. That's really interesting perspective to hear about your experience with how that worked in practice. So we only have a couple minutes left before we have to end the panel portion. Although I could ask questions to this group forever, and I have tons more. But I want to ask a question from the chat, which is about conviction integrity units in Nebraska. So for those who don't know, a conviction integrity unit is a division that is housed within a prosecutor's office, and the unit works to prevent and identify and remedy false convictions. So these have popped up all over the country over the last several years. I think there are around 60 such conviction integrity units with inside prosecutors' offices in the U.S. now. So we only have a minute and a half or so, but I'm wondering if any of y'all can answer the question, or all of you have thoughts about conviction integrity units in Nebraska and whether you would support them and how that might help wrongful convictions in the state.
So I definitely need to learn a little bit more about them, but I would be in support of them, and that's something that I would consider within my own office if I was elected county attorney. And I think that's kind of the role that I envisioned a little bit with the public advocate, that they would be an attorney and a current or former prosecutor, and that's somebody that would be able to take unbiased looks and provide inside outside view of the cases that are currently pending, and potentially even previous ones that were called into question.
Yeah, I like conviction integrity units wish there was more. It's just a good systems check. It is a good system check. I'm about to go on a trip. I'm going to take my car in to get a system check. We do it. Cars do recalls, toys do recalls. We system check. And there's nothing wrong with having a system check from within to say, are we really getting it right or are we getting it wrong? Especially when the evidence suggests that there are numbers. You may not agree as a prosecutor's office that the numbers are as high, but most prosecutors' office should agree that they are happening. Wrongful convictions are happening. And you know what? Let's take a look within our office and see. If somebody brings to our attention, we'll take a look at it. I think it works, and I think it goes to how we feel about taxpayers. Those who are I now myself just paid taxes this year. I'm a taxpayer, and I want to make sure that my money is not getting wasted. You would not go on a trip for 30 or 40 days and leave your lights on, discover through your technology that you left the lights on, and then say, oh, well, and just leave the lights on. You would not do that. You would not want to condone that waste. And so there is a decision, there is an obligation, I believe, for prosecutors' office across the country to say, let's take a quick look, make sure we're not getting it wrong or wasting taxpayers' dollars, keeping the wrong person in prison. That's important, because when the wrong person is in prison, that means the right person is out there potentially committing another crime. Low risk to me, great value in the outcome. So.
Thank you. Well, and as I said, I have a million more questions for all of you, and I hope maybe we can get this group together again, because it was so great hearing the perspective from each one of you, and you all bring a different perspective to the table. So thank you to Ricky and Adam and Randy for joining us today. We're so thankful that you were able to be here, and maybe check the chat to see if there are more questions that come in the last couple of minutes. So if the three of you wouldn't mind to turn off your cameras and mute yourselves, and then Leah, if you wouldn't mind to pop back on. Awesome.
Absolutely. Yes. So I just want to thank everybody for attending today, especially for our sponsors for today's virtual event. We just can't do this work without you. Almost every single thing we do in Innocence Work has some dollar amount attached to it. So every single dollar that you make makes a huge difference for us. And if you feel so compelled, we'll absolutely provide opportunities to donate in the chat function and post our presentation today. I wish I could tell you how every dollar means DNA testing for our clients. It means reaching out to help us work on advocacy work in Nebraska and the Midwest Innocence Project in general, to help people just like Ricky, to help people just like Juneal, to do that hard work that we have to do. And it takes years at a time to make sure that we do justice right by our clients. So if you'd like to get involved with us here in Nebraska, go ahead and email us. Rachel shared the email address in relation to CLE credit. It's the same email if you'd like to learn more about becoming involved with Nebraska Regional Advisory Council as well. My last bit, as promised, while we would prefer to share some space with you at a lunch or our usual breakfast in person, we're really glad you could be with us. And while it's not the same, we are pleased to draw one lucky attendee to receive a hosted happy hour from Witch and Gnome here in Omaha, a beautiful charcuterie board, appetizers, wine for 8 to 10 of your closest friends. Again, social distance, please. We did a random drawing behind the scenes of today's attendees using a random number generator program, and you should be able to see that. And congratulations to number 32 on our list. That was Aaron Wetzel. Enjoy your event, Aaron. We'll be in touch so you can collect your prize, your door prize from us as well. So thank you again for spending your lunch hour with us today, and for your generous donations and the time and sharing our work on social media. And again, to our panelists for sharing the wisdom and the stories that you did today. You're making a profound difference for the innocent in Nebraska, and I want to personally thank you for everything that you've done for us. Please enjoy a beautiful weekend. If you're here in Omaha, it's just going to be perfect. So enjoy this time. Thanks again for spending some space with us today. Take good care.
Thank you all so much. We appreciate it.